Digital Rulebook. And so I'm very happy to welcome to the stage Olivier Michael, Head of Unit for Data Protection at DG Justice, Hilke Heijmans, President of the Litigation Chamber and a member of the Executive Committee in the Belgian Data Protection Authority, MEP Marketa Gregova, Ilias Chantos, the Global Privacy Officer and Head of EMEA Government Affairs at Broadcom, and Marianne Fernandez-Perez, Head of Digital Policy at the European Consumer Organization. Thank you all so much for joining us this morning. So I think, as we've alluded to already this morning, there are concerns in some quarters at least that the GDPR, and perhaps even more so some other newer digital laws, are providing a constraint on economic growth in Europe and on innovation. The 2024 State of European Tech report showed that startups and investors have concerns about coping with the volume of digital laws that have been passed in recent years. And 60% of those respondents thought that the GDPR created a challenging business environment. And of course, the regulatory environment is becoming more complex with the DMA, the DSA, the Artificial Intelligence Act, the Data Governance Act, the Data Act, and I've probably forgotten a few others, along with cybersecurity laws as another area which overlaps a lot with data protection. But the question about what to do about this perception, I think, is still open. I think on the one hand, the GDPR clearly serves a very important role in setting a single rulebook to help innovative European firms scale across the continent, even if its ability to set a single rulebook is perhaps imperfect. And of course, GDPR also increases users and businesses' trusts in using data-intensive technology. On the other hand, the Commission, as I think we'll hear, is keen to tackle this perception with a simplification exercise and an effort to improve the consistency of the GDPR with other laws. And finally, there are some policymakers, MEPs, and industry stakeholders that are proposing more radical changes to GDPR, moving perhaps towards a tiered approach where there are less substantive obligations for smaller firms. In addition, I think the EU-US relationship is complicating the kind of global data protection landscape in which Europe operates. We've spoken a bit already about questions about things like independence of regulatory authorities in the US, and JD Vance has referred to GDPR as a law that I think he said imposes a whole lot of costs on American firms disproportionately. So I'm really delighted at the exceptional panel that we've gathered here can look retrospectively at how well the GDPR has performed so far, and also about what reforms we might need to focus on to tackle some of the perceived or actual challenges and criticisms. So I'll kick off with an introductory question to each panelist, but also very keen for this to be an interactive discussion as much as possible, so please feel free to add your comments and questions. Let me start with Olivier. And for Olivier, I think the Commissioner for Justice, Michael McGrath, has confirmed that the Commission wants to simplify GDPR, focused on record-keeping obligations for small and medium organisations. I think this reflects the Commission's broader approach to simplification in the tech landscape, which is focused on simplifying, on improving enforcement and implementation, but not on kind of substantively watering down the core principles of the digital acquis. And so I was hoping you could talk us through why the Commission has taken this approach rather than thinking about more fundamental changes to the GDPR. And do you think that these criticisms of GDPR hindering innovation are as well founded as some make out?
So thank you very much, and hello to everybody. First of all, it's great to be here with all of you today. So to reply very in a straightforward way to your reply, why are we doing that? Why this approach? And you mentioned the possible simplification on record keeping. That because we are having a very pragmatic approach after constant dialogue, I think, with stakeholders, member states, data protection authorities, civil society, business, etc. So we should not forget that we conducted last year a very extensive, evaluation of the GDPR, and to that end, we spoke with all the stakeholders I just mentioned, member states, civil society, data protection authority. So I think we have to be very careful when we talk about this narrative that you mentioned about amending the GDPR, changing the rules, on what very concretely people are speaking about, and not, article in the press or line to take or a statement by one or two individuals, etc. But see what is the majority, what is the view really of the stakeholder, of civil society, of the business side. And what we concluded after this exercise that we conducted last year in our report, which is publicly available, is that the rules, the principles are fit for purpose. That the individuals are attached to the protection of their data, that they do not want systems which are developing in other parts of the world, and that we have to interpret, of course, these rules and these principles in order to support innovation, to support economic growth, innovation, etc. So, and for instance, there are principles like the risk-based approach that you mentioned about the scalability of obligation, which is part of the GDPR, and that has to be implemented absolutely. But we also identified a number of issues when we conducted our report, and they are common sense in a way, even if reference to common sense might not be always good in the international context, but okay. I mean, they are common sense with European characteristics, let's say. So what we need to do is more support to stakeholders. And the chair of the EDPB just mentioned what has been done for SME, that we need clearer guidance. We need more engagement. For instance, this is a message we passed also to our friends in the European Data Protection Board. Even before guidelines are being developed, we need to engage with stakeholders to understand the context, to understand how these guidelines will play. And we are very pleased to see that it is also something which is mentioned in the new strategy of the board. So engagement with the stakeholders, more code of conduct, more support, more certification, etc. We need this more consistency between the different pieces of the digital rulebook, as you mentioned, and between data protection authorities as well. We need more cooperation between the regulator of different pieces of legislation. And this is something which has been mentioned. We need to do that for the AI. Anoutalus mentioned the ongoing dialogue between the Commission and the AI board and the data protection authorities. This is also something we can talk a bit later. I understand there is a panel on that. And we need also to recall that the member states have also the possibility to foster this dialogue at national level. Because there was a question about notification for cybersecurity, I think from MLEX before. Can we have a single channel for notification? I would like to recall that in the cybersecurity NIS2, so-called NIS2 directive, there is indeed the possibility to have a single channel of notification. Are there many member states who have used this opportunity? Not three, not one, three, I think. But we have a margin of progression, Ilias, I fully agree with you. So this is important. And then what has the Commission been doing on that? Taking this state of play, I realize I'm speaking too much. The GDPR procedural rules, indeed, as was said, we want to foster early consensus between data protection authorities with very strong hope that we can conclude this negotiation thanks to the rapporteur who is here present and Council presidency under the current presidency, so before in May, June, hopefully in May. And then we came with this idea of simplification of record of processing. It didn't fall out of the sky, this idea. We have mentioned it in our report in 2020. We mentioned it in 2024. We hear the SME telling us it is, and the SMC, so the small mid-caps company until 500 employees. And we are implementing that, and this is what is planned to do, pending validation. If there are other ideas to simplify the GDPR without touching on the rules, without touching on the principle to which we are all attached, of course we are in constant dialogue and we are happy to listen to any suggestions. Thank you very much.
Thank you so much, Olivier. I'll move on to Hilke, and I think, you know, from the Force's point of view, I'm keen to understand one of the key benefits of the GDPR in terms of enhancing European competitiveness is if it provides us a genuine single market for regulation of personal data. And you know, there have been criticisms that there is kind of patchy enforcement and inconsistent enforcement across Europe. And so I'm wondering, from an enforcer's point of view, you know, how would you rate the GDPR's success in achieving, you know, that promise of a single market? And you know, has it succeeded? And if not, what do we need to do about that?
Let me make one step back. I have the role of a national data protection authority. I enforce fundamental rights in a member state. We have a lot of concerns, one of them being the single market, etc. But it starts with protecting individuals on an individual level. And I think if you look at the basis of what the GDPR is meant for, it's meant to protect individuals' fundamental rights. And the question was posed to me before this panel, has the GDPR been a success? If I look at it from the national perspective, from the local perspective, from seeing what happens here in Belgium, I see a lot of things that happened over the years. There's an enormous compliance culture within companies here in Belgium and also outside of Belgium. There's an enormous compliance culture anywhere. There's a whole community that developed of DPOs, of other professionals that work in the area of privacy. So that's where it all starts from, and individuals should be protected, should have some control in a world which is becoming more and more complicated. And that's our basic role. That's where we stand for. So then, of course, we should look at the wider picture as well, at the economic picture, etc. But this is where I would start. And I also would like to say that there's an enormous acquis, what we have done over the last years with the GDPR and then all the guidelines, for instance, of the EDPB and other elements. There's an enormous acquis, which is the basis of, and Anatalo said it in a perfect way, technology should develop, but meeting our European values. So that's my starting point. Under the rule of law, we should ensure that if we make laws, and that's the second point, that they are also enforced in an appropriate manner. Then, starting from this point, also looking at, of course, we hear and we see that companies, and especially SMEs, they have to comply with a lot of bureaucracy. That's all quite often said. But if you look at the GDPR quite quickly, this risk-based approach is especially meant to ensure that they do not have to comply with all kinds of enormously difficult regulations. I'm not talking about Article 30 on the record-keeping thing. There apparently are good reasons to simplify it. But that's the main message I would like to convey. Of course, we read about competitiveness, fragmentation, I think, is an issue. I think fragmentation between member states is a big issue, which hampers, on the one hand, the single market to develop, on the other hand, also can be detrimental for individuals' fundamental rights. So fragmentation is a big thing. I think in the EDPB and also outside, we're working on that. And I think also there, in that case, I really I really support the proposal for these procedural rules, which can ensure that we, at an earlier stage in enforcement cases, work together. It's an enormously important additional instrument. Maybe we need additional instruments, for instance, to ensure the interregulatory cooperation with other kinds of authorities. And I think there is a big issue there for several reasons, because we have all these acts with all with their own enforcement mechanism. on the European level, but also to make it even more complicated, every member state does it in a different manner. So maybe there's something also to gain. Coming back to your initial question, I think, does the GDPR hamper innovation? I think that was more or less what you wanted to know. I always say, and I believe in it, that the GDPR is not the problem. The GDPR is complicated, but if we do it in the right way, with all the guidance, etc., it can also provide legal certainty, upholding our values. And that's, I think, is the important thing. Of course, it's easy to say everything works well. Of course, there are challenges as well. I will not say that there are not. AI definitely is a challenge. To what extent can a GDPR completely function? Do all the principles apply in an AI context? There was an interesting article here in the local newspaper, The Standard, last weekend, challenging the question whether or not the accuracy, the right to have your data rectified, could work in an AI context. Those are questions we have to look at, but we have to look at it in a pragmatic way, seeing to what extent we can make it work. Maybe adapt things in a way that is taking account of our fundamental rights, but on the other hand also, of course, not acknowledging reality. And another point, I think it's already been made, GDPR means also always constantly balancing with other fundamental rights, with other interests, with economic interests, with the single market interest. That's our work, our daily work as authorities. And of course, in that respect, we can be held into account that we ourselves don't become too dogmatic in how we think about data protection. So in our strategy, for instance, we put clearly that always, in any case, the outcome, it's outcome based. We try to look at when we enforce that the impact in society plays a big role. Final remarks maybe, AI is a challenge, the changing world is a challenge. When we talk about harmonization, one of the things I see at national level, for instance, that there is a big difference also in how courts apply the GDPR. So that's another layer where harmonization and fragmentation plays a big role, which I think we should maybe look at. So far.
Thank you so much, Luca. I want to touch on one of the points you raised, which was about the procedural regulation. And it's a great honour to have Ms. Gregorova here as the rapporteur for the procedural regulation, which is making its way through the trilogues now. Clearly this regulation is going to hopefully solve a number of the problems with the one-stop mechanism, which have been well known for a number of years. And I'd really like to get your views on, the direction of these negotiations. I think there are a lot of questions people have about, for example, whether there will be timelines setting out how long the process is going to take. I'd really like to understand how successful you think it's going to be at solving these challenges, or whether it's just the first step in a broader series of reforms that are going to be necessary to promote more cross-European harmonization.
Thank you for the question and for inviting me. Hi everyone. I will not give you exact timelines yet, although you are absolutely correct. That is one of the priorities that we are trying to negotiate, but I don't want to give you spoilers, and also we didn't agree on it yet. However, I can give you a spoiler, it should not be 5 years anymore. There are some cases where this is happening, and this is what the procedural reform is trying to change, apart of many other things which I will mention. So we are trying to improve the effectiveness so that we have more reasonable timelines. And I think we have overall agreement with other respective parties in the negotiations. Given agreements, we also, especially the Parliament and the Council, we are quite on the same wavelength in terms of reducing the burden on authorities, so that as many cases can be dealt with as quickly as possible. So that is related to the timelines question, but if you can technically, like with, let's say, content or happiness of both parties, respective parties, close something even before it arrives, and a court and an authority, then everybody will be happy and nobody will be overburdened. And I think that my colleague from Data Protection Authority can say that there's a lot of cases. Of course, that more complex cases can require more time, can require more administration. However, we are trying to also make like a summary of key issues and other procedural requirements before, so that later on, when the authority wants to already close the case, there are no duplications. You don't need to say again that something like you went through. How do you call it? Some conflicting elements that would later emerge, and you need to deal with it, otherwise it will delay it. And last but not least, what we are sort of trying to do is also streamline the rights of the parties in the procedure, as well as some administrative elements, such as confidential information, which information is to be shared between the authorities and the parties, etc. This has been an ongoing request from both the sides of various lawyers, authorities, but also NGOs. We are, of course, me especially, directly elected person representing many opinions, some of them partially conflicting. So we are trying to accommodate to it by really giving everyone enough information, but not overburden. And to your question about the future, well, you did not say the word, but we have heard from the Commission the word omnibus very often currently, and cutting the red tape. Well, we would hold our horses in this regard, not to reopen GDPR completely, given, of course, not only the complexity, but also the fact that we did not implement these changes yet. So we need to first see the impact, where are potentially any loopholes, and then, of course, we could cut some red tape. However, the omnibus, of course, could definitely address the real elephant in the room, which is overlapping legislation. And you mentioned cybersecurity, the NIS 2, and of course also AI Act. So the reporting obligations with GDPR and NIS 2 could definitely be harmonized, which would mean cutting the red tape. And also the fundamental rights impact assessment and GDPR data protection impact assessment could also be sort of made simple. So I do hope that the Commission's direction would go here and not into reopening and deleting everything. That would be really a loss of a very long work. Thank you.
Thank you. Now, Elias, just from an industry perspective, I mean, a number of us have already spoken about this dilemma between maybe more procedural, administrative, or record-keeping changes and more substantive changes to GDPR. And at least some businesses have been pushing for a more radical approach. But it does seem to me that there are questions about that, not only in terms of whether it would substantively water down fundamental rights, but also around the legal uncertainty about kind of reopening a file on which there are many conflicting and powerfully held, strongly held views, and also creating legal uncertainty when we have a law that is, has been bedded in for much longer than some of the newer digital laws, and where I think interpretation and enforcement are becoming a bit more mature. So I'd really like to get your views as someone from industry on whether the Commission's approach here is the right one.
Commission approach is always the right one. So I work for a B2B company, right? So I want to take a step back. If one would ask me the question, is GDPR a success? Has GDPR been a success? Unequivocally, strongly, without a doubt, yes. Absolutely. And not because I got a job because of GDPR. But I'm the Chief Privacy Officer. I got a job because of GDPR. In fact, many people in Brussels have a job because of GDPR. If we want to be also, disclosing conflicts of interest. But the reality is, as I have to look at the work that we're doing around compliance globally, GDPR has given me the global frame of reference. Point. Okay, as simple as that. And you know what? It's really easy to attack something when it's the first one. And we need to be mindful of that. Overall, GDPR is fit for purpose. Overall, GDPR is a text that, let's say, meets our values. And I will also go as far as to say that a lot of companies have built their compliance programs and structures on the basis of GDPR. So you know what? I don't want all that investment to be a sunk cost. I don't want it to go away. In fact, if I wanted to be critical, not only of you, but other departments of the Commission, is that they've added too much new regulation, which has muddied a little bit the water, in which we have tried to comply with, building further and expanding on what we've done on GDPR. So overall, we have a solid foundation. Now, the discussion really needs to be, in the light of what's going on around us, do we need changes? I'm many things, but I'm also a political realist. And in that sense, reopening GDPR for it to be torn to pieces between conflicting views is not really the objective that we should have in mind. Targeted changes, you know, we can debate. A lot of it is down to interpretation. Some of it is down to fine-tuning. But it really, you know, it's really on the edge. It's not about, oh, we need to radically think what it is that we're doing. I think the fact that a lot of other countries around the world have even taken stock and gone the same place or further is an indication that we hit the mark.
Thank you very much. And finally, let me move on to Marianne for a consumer perspective. And I was wondering that maybe you want to reflect on this discussion that Ilya's just opened about you know, whether incremental change, a better focus on implementation and enforcement is right, and whether, you know, the extent to which you feel that fundamental rights might be undermined with maybe a more radical approach to reform.
Thank you very much for the invitation and also for allowing the consumer interest to be represented in this debate. I think what I hear is consensus that GDPR is not the problem. And thank you for putting words into my mouth, because my main message is that we need to focus on implementation and enforcement. That is what the real problem is. In our view, it's not just news, like what I'm saying is based on our experience, complaints from consumers, and basic data. I would like to remind or think about for a moment, why do we have the GDPR? So in our view, it's about protecting people's personal data, right? And it has very concrete implications, not only for our rights, but even for our pockets. It's about me not needing to pay more than my neighbor because of the data processing that happens. It's about a black person not to need to pay more just because of the color of the skin for a financial product, and yet this is a practice. It is about ensuring that companies do not do whatever they want with their data. Yes to innovation, no to doing whatever with that innovation. And that's what the GDPR and also other laws in the European Union that are very much needed shape the innovation. They basically accompany the company's innovation, and that is really good. What we see, however, is that people have concerns. Just last week, the European Commission released the Consumer Scoreboard. 93% of consumers are still concerned about targeted advertising. Yeah, and then top 3 concerns is what is first. The first one is the data collection without consent. The second one is excessive ads, and the third top concern is unavoidable personalization. The GDPR have answers to that, but we need to see those concerns addressed in practice. I agree very much with what Olivier said. We need to be pragmatic. What consumers need is those protections to work in practice. And also in the consumer report that I mentioned before, it was clear that only 5% of consumers bring a company to court. And we're not even talking about only the GDPR, just in general. So we need to ensure that companies really take it seriously, and for that the GDPR needs to be deterrent. Non-compliance need to have serious consequences. We, for example, did a coordinated action against Google data location tracking. It's been more than 6 years, 6 years and a half. We still don't have a decision. I think that speaks for itself that the enforcement is not working. What we see as possible solutions, one can be the procedural regulation that we just discussed. What we want is to ensure that complainants, those that actually take the courage to complain, get decisions quickly, because some of the reasons why people don't take companies to court or complain is because of the lack of time that they have, and also they think that the chances of success are low. Some of the reasons sometimes can be procedural. And so we need to alleviate the burden for people, but also for authorities. We see the need for creating more synergies and efficiencies, and to ensure that there's set for success. Because data protection authorities and also courts are there to protect the people's interests and have a balanced view on the basis of the facts presented. But they need to have the resources and also means and not be distracted or overburdened by procedures or lack of clear deadlines or even legal basis to cooperate or to share some information with authorities or even the parties involved. So we urge caution about any calls on so-called simplification. I mean, I ask simplification for whom? Is it simplification for people? Or is simplification for companies for the sake of what? Where are we sacrificing even for records processing? In our view, even the records processing are an accountability tool to ensure that you as a company are taking your obligations of data protection seriously. And so we need to make sure not to have unintended consequences with any simplification exercise. Also because if we look at the timelines proposed, we expect, if I understand correctly, something by the end of the year. We would like to see a proper consultation on the basis of clear dispositions. Also, reassurances about not opening up Pandora's box. Because maybe you can think of targeted amendments, but we have a co-legislation process. How is that going to work? And so I go back to my initial message. Let's focus on the real problems. Let's focus on setting the GDPR as a success for businesses and people, and make sure to create a level playing field between those that want to comply and those that don't, because that's the real issue here. Thank you.
Thank you. Thank you for those really insightful opening comments to frame the debate. I have maybe an initial follow-up question for Olivia and maybe Hilke, which is just about how the engagement and cooperation between authorities dealing with data protection and those dealing with digital competition under the Digital Markets Act, Artificial Intelligence Act, authorities and others are going to be able to interact, because I guess these are authorities that have a very different mindset sometimes in terms of the problems that they're trying to solve. And also, I think the sheer number of authorities that are involved. I mean, you look at the AI Act, and there are potentially hundreds, some of which are sector-specific within individual countries, that are all going to be engaged in interpreting, applying, and enforcing these laws. It's looking like a very complicated landscape in terms of the number of actors that are going to be involved when you're dealing with issues like the accuracy of AI systems, where GDPR and the AI Act, potentially other laws as well, all have kind of a quite close interaction. And so what I'm wondering is at a really practical level, how we can get cooperation mechanisms that are going to be as quick as and as efficient as they need to be, given how quickly these technologies are developing and new services are evolving.
Thank you, and thank you for this question, because we are moving actually to the substance of the issue, away from let's change the GDPR. The GDPR is a burden and so on. But I'm sure that once we are all out of this conference, I will receive for sure questions from the press about that, or statement or parliamentary question on why the GDPR is a burden. So it's a bit of a Sisyphean, process, but I'm grateful for this conference because we can at least have another discussion on that. So to address your question, I think this is really what we need to tackle. This is about this enforcement, implementation, consistency, ensuring legal certainty. And of course, there are in these various acts that you mentioned, there are a number of tools. On the DMA, there is a high-level group where the data protection authorities are represented. There is also what I mentioned, that the member states, they can appoint data protection authorities for some of these acts. It's their choice, it's for them to decide, or at least they need also at national level to ensure this consistency. But when there are issues, and you mentioned specifically AI, and I know that my colleague here from DG Connect will participate to a panel on that, we had also a discussion in the council, thanks to the Polish presidency, both the AI part and the GDPR part, on precisely how now to ensure this consistency. We know that, of course, the Commission has to prepare guidance on AI. We know that the European Data Protection Board is working on guidelines, and there were several steps taken, as Anutalu's report. So now the question is how to ensure this consistency, how to work together so that we can tell an operator, you don't have two sets of guidelines, or even contradictory guidelines, or not fully compliant guidelines, but something which is very actionable, while respecting all the objectives, because I'm not sure there are a lot of people talk about overlaps between legislation. They have different objectives. DMA is the contestability of the market, the DSA is about illegal content, GDPR is data protection rules, AI has its own objective. So it's not so much that there are overlaps, but they have to work together. And this is what we should strive as a commission, as a various regulator, all within their own competence, their independence, and in a consistent way. And this is a big challenge, because it's very easy to say we are all working together, we are all friends, and we will come with something very easy to do. It's not easy to do, but this is a duty we have. So, and I think we should focus on that, and not on, let's, as Ilya said, when you reopen a Pandora box, you don't know what will come out of it. But we have to be, again, very sober, very down to earth, very pragmatic, how to make things work. We should be looking at the mechanics and helping enforcement, guiding, compliance. This is what we should be doing. Thank you.
Thank you.
If I may add a few things, I think I fully agree with Olivier. I think it's important for us now all to make things work and not to change the rules constantly. It's to ensure better enforcement. That's also the message I heard from Beuk just now, from Marian. This is what it's about. There's a lot of criticism on our enforcement. It's not quick enough, that's true. It's not strong enough, maybe that's true. And it becomes, but now it even becomes increasingly complex, because we have to deal also with all kinds of other regulations and interactions. You can say that they can live next to each other. I think that's not really always the best option, because there is so much interaction. When you talk about elements we already mentioned, for instance, non-discrimination, automated decision-making, right to explainability, targeted advertising, there's all kinds of elements of what we do which are also now dealt with other authorities. So what we are doing at national level, for instance, is one day we had a conversation with our national competition authority, how we can indeed effectively work together on a protocol, how we inform each other, and also how we can make use of each other's strengths and each other's skills, each other's expertise. So I think at all kinds of levels we should work together and see how we indeed can make good regulatory mechanisms put in place, so that we indeed our enforcement strengthens each other and not divides. And that's even more important, because what I've seen over the last years working in day-to-day enforcement is that also companies who are the subject of our enforcement also are stepping up. We get a lot of procedural issues every time to deal with. Law firms, lawyers come up with all kinds of arguments which are procedural nature. I don't blame them, that's their job, and there's nothing wrong with it. But if we make the environment even more complex with different regulators, then you can imagine how more complex also that part will be. Is there a solution? I think we should work in 2 steps. The first step could be indeed all kinds of working groups where we work together. There's this DMA group, etc. But in the second, and we should do that on the national level as well as on the European level. The second step for me will be really thinking if we need a new regulation, it's the way how we can ensure that these regulators work together. So it should be more on procedural. It's a second procedural regulation on top of the one you are already working on to make it even more complex. But don't touch the GDPR as such, principle level, don't throw the baby with the bathwater, I would say.
Would you like to add anything? Elias, I think you had a comment or two.
So, I agree with Heike completely about the importance of regulatory coordination, but because there seems to be too much consensus on this panel. let's try to go a little bit in the mechanics, not to show that we need a change in the values, the principles, nothing of the sort, but to just show some examples from practical experience that may justify adjustment, course correction, slight different interpretation. As I said to you, I work for a B2B company, right? So DSARS, data subject access requests, is not a major issue for us normally. At the same time, and nobody questions, by the way, the value of DSARS. They're there, we need to have them, etc., etc. At the same time, we see a tendency of weaponization of DSARS in the employment context. I want a more favorable exit settlement. I'm going to go in and ask for a DSAR, a data subject access request, because I've been a 10-year employee. And by the way, a 10-year employee, I can tell you, because I've experienced this, will generate, on the first search, about 100,000 documents. 100,000 documents that we need to review. And if we follow the rules in certain member state jurisdictions, we need to print them, redact them, and provide them. So I want you to picture the truck with a forklift arriving at the house of that individual with the trees cut in the amounts of paper that needs to be produced. When they first came to me with, Elias, we got to review 100,000 documents, what got into my mind was, have you seen the movie Das Leben des Anderen? The image of the official basically listening in, us having to go through all those emails, all that content. For what? To prove that essentially we have data as data controllers for that particular individual? Absolutely. That's one example. Mergers and acquisitions. Article 18 of GDPR says that if I receive the data indirectly from a third party, I have to let the data subject know within a month. Very reasonable in the context of advertising or other purposes. The problem is, I have to receive the data when I'm doing due diligence because I need to design, or I have to disclose them, because I need to design how the new organization that I'm acquiring is going to look, or I'm selling out, is going to look like. But the problem is, if I have to do one notification within 30 days, how will this work in practice vis-a-vis the secrecy of the diligence? By the way, folks, China has in their privacy law a mergers and acquisition exemption. GDPR was first, we didn't think about it. Okay? So that's really more, I mean, that shouldn't be a big deal. I'm not going to go at all into the discussion about incident response and all that. That's said in Brussels already 100 times. Third example, I was working to implement CPRA. CPRA is a CPA, California privacy law. Guess what? We're complaining about competitiveness. The Americans are actually saying, the Californians, I should say, are saying that product improvement is a legitimate business purpose. Now, I understand we have legitimate interests, we need to be doing the balance testing, we have concerns about other use cases that may not be, in line with our values. All that's fair. But on the other hand, let's face it, we put another legislation to figure out how we're going to do data sharing. So we need to be thinking about how we will enable product improvement on one hand, while on the other hand, not jeopardizing fundamental values. So these are some, and again, that's an interpretation question. That's not, let's change the regulation question. So here are a few, there are more, but here are a few practical examples that make day-to-day practice, let's say, impactful or not, depending on which way of the fence you're going to be.
Thank you for adding some controversy. I was tired of being the devil's advocate. But Marianne, do we need more protections against weaponization of subject access requirements?
I'm not sure consumers actually would weaponize their rights. In fact, if anything, consumers do not exercise their rights enough, sometimes because they're not even aware. And in your example, I think there's so many questions and we don't have the information to assess whether that is fair or not. Why does an employee take the courage to ask these questions to their employer, and under which circumstances would someone be so desperate to do that? Because of course they know that they would have some consequences. So I would need more information to assess whether that would be an abuse, and I would not jump and say that that would be something abusive. If anything, as I said, the consumers do not exercise their rights, and when they do, as I said before, it takes time to get a resolution. Sometimes they don't hear anything, or they don't even know to whom to go to. So more awareness raising would be the first point. And I'm actually proud that the employee would know their rights. But we don't work on employment rights at Bill, so it's just a personal note. What I wanted to say is that I very much agree with the fact that, so we agree in this panel that we should not touch the GDPR. I think as head of digital policy, I've also had the pleasure to work on other digital rules in the EU in the past mandate and for some time now. We needed the Digital Services Act. We needed the Digital Markets Act. We needed the AI Act. It could have been in other forms. Yes, you know that Bill has always ideas about how to make EU laws better. And we need not to just say, oh, the EU did legislate without thinking. There has been a lot of thinking. There has been a lot of evidence gathering, consultations. The Digital Markets Act is bringing more competition into the market. It's good for businesses and consumers. The Digital Services Act is bringing more accountability and safety to people. And we actually are very happy that the European Commission even announced the need to propose a Digital Fairness Act. And it's not just about women to protect just for the sake of it. It's just that it's also, again, costing people money. The very thorough fitness check that the European Commission conducted on the Digital Fairness Act showed that people actually are losing almost 8 billion a year for unfair commercial practices. We have regulations that are dealing with things like dark patterns. Also in the GDPR, some dark patterns can be addressed. You know how many of the most popular apps and websites have at least a dark pattern? 97%. 97% of the most popular apps and websites have dark patterns. So we need to also streamline and clarify regulation to make it better, simpler to comply, and also to have a deterrent effect of not complying. And that's why we ask at BEL for a digital enforcement strategy to ensure that enforcement of the laws that democratically we decided that we needed, with ups and downs, they're there, it's a matter of rule of law. Now they need to be respected. Europe needs to be taken seriously, because I think it's really shameful that even when the EU is trying to wake up and enforce their laws, there are foreign interference and businesses just complaining or throwing numbers about costs for not enforcing what we agreed that we should have in the European Union. So we need a digital enforcement strategy in the European Union to make things work for people, but also for businesses that invest money into respect people's rights and their obligations. It can start with soft measures, like for example protocols, also memorandums of understanding, which I know that data protection authorities, many of them have, but also with other authorities. But it's true that maybe we need to think about whether legislative measures are needed, not because in some member states this is not possible, but in some member states an authority is prevented from, for example, for asking questions that are very specific to the facts of a case, because of some procedural constraints. They cannot do that. And yet, the same company actually knows what is telling each individual regulator. So we are not setting enforcers to success. We're setting companies that potentially breach the law to success, and that is not fair for people or for businesses. So we call for a digital enforcement strategy, and what can be done to address, so-called overlaps. I would also think that it's very important to remember that even in the Digital Services Act, DMA, AI Act, these supposed overlaps have been addressed. So there are recitals, there's articles that address this, and of course we need to see in practice how to streamline. But I want to raise the attention to one proposal that 16 member states have proposed recently, which is to have a digital services handbook. Actually, when I read it, I thought, maybe that's a very good idea, to have a place where they have the obligation explained and know who they can ask for more information. That is an excellent idea, without thinking that, let's reopen everything, even the AI Act, that, for most of it is not even applicable yet. So let's have a pause, not jump into conclusions that are not based on evidence. Also, because a final anecdote, if you go back to the negotiations of the GDPR, do you remember that there was a campaign by some businesses that were trying to show that, well, if you adopt the GDPR, you won't be able to send flowers to your partner. How many people have received flowers here? I hope many, not all of you. I think the GDPR has not prevented that from happening, and yet this was the discussion at the time. So I want to, again, urge caution, let's have discussions on evidence and with the protection of people in mind and fairness across business.
Thank you. Liz, do you want to reply? Can I ask you to make it very quick?
So, the point about the DSARs was very specific in the context of employment, and particularly in the context of an employment dispute. No one is questioning the value of DSARs in the context of consumers or consumer requests. The question that I'm raising is about the utilization of DSARs in the employment context only, and in a manner which I described and I believe to be essentially abusive. So we need to, let's say, realize it. By the way, it's not a question about the employee being desperate. It's a question about the employee basically wanting to get wanting to force in particular conditions an exit settlement. So it's not about somebody not being able to exercise their rights. There's no retaliation, and whoever would believe that there's retaliation in the context of the DSAR is actually going to be anyone trying to retaliate in the context of a DSAR is going to be in serious trouble. We will absolutely not permit that. So much more limited, much more specific.
Okay, and Marquesa, just a final
Just very
comment on
quick.
this.
Yeah. I originally did not want to add further comments, but given that there has been many mentions of the overlaps, and I do think that we have an overall agreement on the panel, but there are of course different ways. I wanted to mention two things that were sort of not mentioned yet. One of them is that you also, when you want to complain as comply, as a company, you also put together certain compliance teams. And if you make them diverse enough so that they understand the various European legislations, DSA, DMA, AI, etc., and GDPR, then you can combine their knowledge. So for instance, restricted targeted advertising helps also compliance with the GDPR. So person focused on that can cover both. Or complying with the DMA on data governance helps comply with GDPR when it comes to data portability. So there are many overlaps. And last remark, which I don't think it was mentioned, maybe because of the sponsors above us, we can say whatever we want, right? I also feel like the very, very data thirsty companies will put much more money into finding ways to not comply, when it would be much cheaper for them to actually try and comply. Recently there has been, I'm sorry I will say it, a Meta case, where they tried to pretend that by registering on Facebook you are signing a contract where they can use your data for advertising. And now they are actually trying to make the pay or consent model, which might be even illegal under GDPR, we'll see. So that's also something that of course, I'm talking to you as consumers also, should push in terms of like the companies this, because as was already mentioned with the lobbying, there will be always somebody who will claim you can't send flowers, or you have to click these hundreds of windows regarding cookies or something, and that's because of the regulation. But sometimes the regulation is much simpler than what the company makes it seem.
Thank you. Although I might say that maybe there's another element to this lobbying question, which is that when we're thinking about entrepreneurship in Europe, it's really small firms that often complain that GDPR is the barrier to starting or growing a business, and larger firms that are
tailored guidance needs to
yeah.
be here for SMEs, absolutely.
Yeah, I'd really love to open to questions. We've got about 5-6 minutes left. I'm sure there'll be quite a few. Maybe this gentleman here to kick us off.
Good. I'm one of the guys in the House of European History. A question for the representative of industry. You spoke about too much regulation. You are not the only one. We spoke about this already 25 years ago. Question to the member of the European Parliament. Do you think one day there will be a commissioner whose only competence will be reduction of regulation?
Thank you. Before we go back to the panel, can I just see if there's any other questions in the room? Oh, I'm sorry.
I'm Marcel Sixay from Advancia Bank, and I have a question about the GDPR and its interplay with the AI Act. So what will be the main approach when it comes to overlapping provisions? So for example, when it comes to BPIAs and fundamental rights impact assessments, can we expect regulatory changes on that, or is more like there will be an approach with the guidelines?
Thank you. This is probably the last chance, so please do raise your hand.
I have a question.
Thank
What I
you.
can do to get to the question. I'm sorry. Thank you. Thank you. Hello. My name is Isabella Demichelis, and I'm the founder of Ernie App. Actually, the only privacy that allows you to change privacy settings, configuration, and every third-party app with authentication. So the question is contextual. Why are we in the belief that we need to have two rules for small and big companies, but we have 95% of smaller companies not respecting GDPR? That's a question for the panel.
Thanks. Okay, so maybe if we can aim to keep these remarks quite brief, maybe you might want to just tackle one of the 3 questions each. I think the first one was on better regulation and whether we'll have a commissioner for better Russian. I mean, we already have a lot of rules like one in, one out that are getting implemented. Although that hasn't necessarily slowed the pace of legislation in the last commission. Secondly, on the AI Act and fundamental rights impact assessments. And thirdly, on non-compliance by SMEs. Perhaps Olivier, if you'd like to kick us off.
Okay. Thank you.
Sorry to
Go
throw you in
first,
there.
Go first, it might be dangerous. So, I mean, on the reduction, I mean, the question should be rather, what is the overall objective? Once we know the objective, we have the relevant regulation. And I have a lot of sympathy, of course, for especially you mentioned the small business with very few people, and they have to comply with a different regulation. And this is why I think the risk-based principle embedded in the GDPR, which is there, has the scalability of obligation, has to be fully implemented. And this is why we didn't think that the record of processing was such a big burden, but we heard that coming from the small and medium-sized company, and we extended it, we plan to extend it to the small mid-cap, because we hear that. So this is indeed what we are indeed, again, we are listening very carefully to the needs of especially the small players, with due respect to what Elias and big companies are of course very important to us, but we have indeed a special attention to this small organization. On the fundamental right impact assessment, data protection impact assessment, again, the colleague in charge of AI might want to speak about it, but the idea, I think, is to work as closely as possible with the European Data Protection Board and the data protection authorities and the AI board and the colleagues in order to have something which is consistent, feeding each other. I don't know what will be the outcome, but this is very clear that we need to do that. And on non-compliance by SMEs, I would leave it to the enforcer. I think honestly that a lot of companies they do their best to comply. I would not go against rogue companies not complying and trying to cheat the system. I think I genuinely believe that the reasonable and the responsible business community, they want to comply with legislation, and then all our task is to make that compliance, I think, easier, that we can support them in their compliance effort. Thank you very much.
Thank you.
A lot of things I could answer to.
I'm afraid you have about 20 seconds if I give everyone the same.
Especially to Ilias' story about data subject requests, because that's our day-to-day business, to ensure that we find a balanced way in treating these access requests. No time for it apparently to react. The DPIA and the FRIA, I think that's super important that we as enforcers work together in all the levels we work, nowadays at national level as well as the European level, to ensure that we do this in a joint exercise. You don't have two different impact assessments taking place at different moments. So that's really a challenge at enforcement level, I think mostly. The digital strategy, enforcement strategy, I think certainly a brilliant idea, so we must work further on that. And I don't know what else I should say about non-compliance. As I said, and that's my starting remark, what I see in Belgium, I don't think it's true that 95% of the small companies do not comply with the GDPR. They might not comply maybe with certain specific provisions, but there's an enormous activity taking place. There's enormous action taking place. It is, you see that many companies put in place mechanisms, there's all kinds of tools given to them to make it work. So I don't agree with the argument that 95% does not comply, without having statistics, by the way.
Thank you. Any closing remarks?
Yes, 20 seconds. Okay, so first of all, Dombrovskis is the commissioner in charge actually already, and of course all the others are working on it too. So if it's enough, I don't know, but he sort of is like that. And I will also choose to answer, or try to answer your question. Well, from my perspective, I think the way is not to just give SMEs easier guidance, because yes, some of the things are very complicated to implement, but also make things by default and by design already, like regarding privacy. For instance, the Do Not Track initiative should be something that should be the leading one, you know, so that everybody has the same default position. If the default is we protect everyone's data, then everybody will need to adapt by design to that. So that was.
Thank you. That's very concise.
So very, very quickly, do I believe that, let's say, we're going to do away with the regulation completely? No. Why? Because this city works with this system. And quite frankly, with 27 member states, you need rules. It's by design this way, and it should be this way. So really, not much of a choice. Do I believe that there's going to be overlap between data protection and AI and let's say, is this something we need to tackle? Yes, we're tackling it already, is in a nutshell the answer from my perspective, in the sense that we're trying to integrate governance and controls to check every time everything that gets with AI inside, all use cases of AI are reviewed by legal, and we understand whether we're talking about personal or non-personal data, as well as understand the risk associated with that particular use case. But because it was mentioned, the discussion about a lot of regulation, and you said you work for a bank, don't just look at AI, look at DORA, for example. I would, in my view, there's much more overlap in terms of the controls from a DORA perspective than necessarily the AI perspective. AI is a lot of use cases without at all personal data, code development. So don't just focus on AI and GDPR. Final point, I'm not the one who will comment about SMEs. I'm not working for an SME. However, what I will say is something that I have observed with other large companies that have SMEs in their supply chain. and it's an economic one. The more regulation we add, the more, irrespectively of what this regulation is about, the more difficult we make it for European SMEs to compete. The more difficult we make it for European SMEs to compete, the less innovation and the less likely we will make it for sovereignty. So, from my perspective, this is a pure economic argument, an economic discussion. It does not necessarily have to do with, in of itself, the compliance debate.
Thank you. And finally, Mary.
Thank you. So on the question on too much regulation, I actually concur that actually the European Union streamlines regulation because the idea is instead of 27 rules, we have one. So I think it's in the interest of both people and businesses. And I also agree with what Olivier said, that at the end of the day, it's about why are we doing this and what is the evidence. And I think if we follow better regulation principles, that unites both businesses and consumers. We both ask for these, then we can have good regulation. On the 95% non-compliance, I mean, I would like to see more of the numbers, but it's true that from a consumer perspective, it doesn't matter whether you're a big company or a small company. We want our rights to be respected. And so that's why we also urge caution, because we talk also about who are these companies and who, I mean, do they even have the time to come to Brussels to lobby for this? We raise some eyebrows about who are the ones pushing for this. Also, when we talk about small mid-caps, because if we're talking about companies with 5,000 employees, to me that sounds like you have a scope to do a record of processing. So I asked the question and urged for caution. And on GDPR AI Act, as I mentioned, the overlaps were addressed, and I think I look forward to the guidance that the AI office and the EDPB will provide, because that will be very good, also for clarity for implementation and enforcement, and I think we can have the solution there. Thank you.
Thank you all so much. I think to recap in the smallest nutshell possible, I would just say don't throw out the baby with the bathwater seems to be the consensus from this morning. Please give our panelists a huge round of applause.